The inventive step in non-obviousness reflects a general patentability requirement present in most patent laws, according to which an invention should be sufficiently inventive, i.e., non-obvious, in order to be patented. In other words, the non-obviousness principle asks whether the invention is an adequate distance beyond or above the state of the art. The expression inventive step is predominantly used in Europe, while the expression non-obviousness is predominantly used in United States patent law. The expression inventiveness is sometimes used as well. Although the basic principle is roughly the same, the assessment of the inventive step in non-obviousness varies from one country to another. For instance, the practice of the European Patent Office differs from the practice in the United Kingdom. Rationale: the purpose of the inventive step, or non-obviousness, requirement is to avoid granting patents for inventions which only follow from normal product design and development, in order to eventually achieve a proper balance between the incentives provided by the patent system, namely encouraging innovation, and the social cost of the patent system, namely conferring temporary monopolies. The non-obviousness bar, hence, is a measure of what we, as a society, accept as a valuable discovery. Thomas Jefferson already foresaw the possibility of patent trolls and sought a mechanism to exclude those patents which only value is to harass producers. Additional reasons for the non-obviousness requirement comprise providing incentives for fundamental research rather than for incremental improvements, and to minimize the proliferation of economically insignificant patents that are expensive to search and to license. Although all countries with actively functional patent systems currently have a requirement for inventive step, the need for such doctrine has been questioned. For example, substantial novelty has been proposed as an alternative approach. Although the need for low bar of inventiveness has been well acknowledged, the proposed means of actually measuring such a bar have all been rather unsuccessful despite 200 years of case law history. A standard that is clear and easy to apply consistently will mark where the non-obviousness bar exactly rests, providing society as a whole, and lawmakers in particular, with a benchmark to gauge the patent system's efficacy. Moreover, such a standard will allow the lower courts to determine non-obviousness correctly and consistently, at least hypothetically, reducing uncertainty, inducing uniformity, and lowering reversal odds, according to the inducement theory. If an idea is so obvious that people in the field would develop it without much effort, then the incentives provided by the patent system may be unnecessary to generate the idea. Thus, there is a need to develop some means of weeding out those inventions which would not be disclosed or devised but for the inducement of a patent. Merges and Duffy regret that the inducement standard was not influential in the legal doctrine, and its absence from subsequent case law raises one of the great unanswered questions of patent law.